Parents are raising alarms after reports of an 11-year-old girl being assigned to share the same bed with a male classmate on an overnight school trip. Should the privacy of hundreds of girls be compromised for one student's identity? That's exactly what's happening in some schools today. What rights do girls have? And what rights do parents have in protecting them? In this video, we're breaking down the constitutional protections, real-life cases, and what it means for children in private and public schools. Now, here's a disclaimer. This video is for informational purposes only and not legal advice. Consult a licensed attorney for legal guidance. There are so many school boards that don't have a clue or don't give a damn about girls' privacy that it is now inherent for parents to step up and start demanding constitutional rights and accountability for their children. Most school board members don't have any legal knowledge, and they make policies sometimes based on feelings and political righteousness. But they have a problem. Public schools are government actors. That means their policies can't just reflect feelings and political righteousness. They're constrained by the Constitution. This discussion isn't about intent or identity. It's about constitutional limits on government action when minors are involved. Once a policy is enforced by a public school, constitutional standards apply. Specifically, what constitutional protections do girls have in public schools when policies affect privacy, bodily exposure, and consent? And where do parents' rights fit into that? Courts have long recognized that minors retain privacy rights in school, even if those rights are reduced. They've also recognized that parents don't lose their authority simply because their child walks into a public building. So the real question isn't whether schools can accommodate students. It's whether those accommodations can come at the expense of girls' privacy and parental consent, and whether the Constitution allows that. So that's what we're going to walk through carefully and factually starting now. To understand this issue, we have to start with a basic principle. Public schools are government actors and are absolutely bound by the Constitution. Private schools generally are not, unless state law says otherwise. Even when the Constitution doesn't apply, federal and state laws can still regulate private and public schools. As an example, the Civil Rights Act, Title IX, and the ADA. But even these laws are sometimes based on constitutional rights. But these examples are not constitutional violations. They're statutory violations. People often mix those up. Not every invasion of privacy by a public school is a constitutional violation, but some policies can cross that line depending on how they're applied. This matters a lot in education policy debates. That matters because constitutional protections don't disappear at the schoolhouse gate. The Supreme Court has been clear on that for decades. But reduced rights are not zero rights. When a school policy involves bodily exposure, intimate spaces, or compelled participation without consent, courts have treated those situations differently from dress codes or classroom speech. Privacy, especially bodily privacy, has long been recognized as an area where the government must tread very carefully. The Supreme Court has been very clear that forced exposure of the body, especially involving minors, is at the highest end of intrusiveness. Courts have repeatedly recognized that students retain privacy interest in situations involving their bodies. For example, cases involving strip searches, locker rooms, and restrooms all turn on the same principle. The more intrusive the policy, the stronger the justification the school must provide. When students are required to undress, change clothes, or expose intimate areas, the Constitution analysis becomes much stricter. Importantly, the standard is not whether administrators intended harm. The question is whether the policy unreasonably intrudes on a student's legitimate expectation of privacy. For many girls, being required to disrobe or change clothes in the presence of a male, regardless of identity, raises serious privacy concerns that courts have historically taken seriously. When a public school compels minors to disrobe in a setting that disregards sex-based privacy concerns, that can raise serious Fourth Amendment and bodily privacy issues under the Constitution. There's another constitutional layer here that often gets overlooked: parental rights. The Supreme Court has long recognized that parents have a fundamental liberty interest in directing the upbringing, care, and education of their children. That doesn't mean parents control every moment of the school day, but it does mean that when schools make decisions involving a child's bodily privacy, intimate exposure, or overnight accommodations, parental consent becomes highly relevant. The schools cannot exclude parents from decisions involving intimate exposure of their children. Courts have generally been skeptical of policies that exclude parents from decisions that affect a child's physical or emotional well-being. Where schools get into trouble: no notice, no consent, no opt-out, treating parental objections as irrelevant. When parents are not informed or are prevented from opting out, the constitutional concerns don't go away. They multiply. Right conflicts don't disappear by ignoring one side. It's important to draw a clear distinction here. The Constitution does not prohibit schools from accommodating students. What it does restrict is compulsion, especially when one group's accommodation requires another group to surrender privacy without consent. Courts often ask whether less intrusive alternatives were available. Could separate facilities be offered? Could privacy partitions be used? Could opt-outs be respected? When a policy forces some students to endure an intimate situation they object to, rather than offering reasonable alternatives, that's where constitutional scrutiny intensifies. Here's another consideration. The Equal Protection Clause is founded in the 14th Amendment to the U.S. Constitution, stating that no state shall deny to any person within its jurisdiction the equal protection of the laws, ensuring all individuals are treated equally under the law and preventing government discrimination. So do the policies disproportionately burden girls? Are the accommodations one-sided? Is the girl's privacy treated as secondary or optional? Some argue this issue is about competing rights, and that's partially true. But constitutional analysis isn't about ranking people's worth. It's about whether the government has chosen a solution that unnecessarily burdens one group to benefit another. Equal protection doesn't require identical treatment in every circumstance. It requires that government policies be reasonable, narrowly tailored, and not dismiss legitimate privacy interests, especially when minors are involved. Ignoring girls' privacy concerns is not neutrality. It's a policy choice, and one the Constitution may not permit. So the real constitutional question isn't whether schools should be compassionate. It's whether policies can be implemented without violating established privacy protections and parental rights. The Constitution doesn't demand that one group of students absorb all the discomfort so another feels included. It demands balance. And when policies involving intimate spaces fail to respect that balance, it's not controversial to ask whether they've crossed a constitutional line. That question isn't hateful. It's personal. It's exactly the kind of question the Constitution exists to answer. So every child deserves privacy and respect in school. If you believe girls' privacy should be protected, take a stand. Share this video, talk to your school board, and stay informed. Your voice can help shape policies that keep all students safe and respected. Don't forget to subscribe and hit the bell for updates on kids' rights, parental rights, and constitutional protections. I'm Tim, and this is Wise Old Farts signing off for today. Thanks for listening.